Welcome to the ADA book. Today we have a very special guest, and that guest is Jeremy D. Richardson. So I'm going to ask Jeremy all about preventing lawsuits, settlement amounts, demand letters, and much more. Jeremy, I'm going to go ahead and introduce you right now. Jeremy D. Richardson is a partner in the litigation and intellectual property practices at Smith, Gambrell, and Russell. Jeremy specializes in representing consumer product manufacturers, particularly in the toy industry, and provides expertise in fashion law, intellectual property licensing, and trademark and copyright protection, and much, much more. But what's also important and relevant to the show is Jeremy also advises on regulatory compliance. So today we'll focus on his experience with website accessibility litigation. And one more important note is that Jeremy has represented clients in New York state and federal courts, and that's where we've seen a lot of litigation for ADA website compliance and website accessibility. We've seen a lot of that litigation in these courts, and so he has also represented clients in the Second Court of Appeals. Jeremy, can you tell us more about your background and in particular your experience with website accessibility litigation?
Sure, Chris, and thanks for that nice introduction. I've handled, unfortunately, a lot of these cases for clients who receive either demand letters or lawsuits. And Chris, as you said, you're exactly right. A lot of these are in New York, either in the federal courts, a bunch of them in the Eastern District of New York, occasionally in the Southern District of New York, and also occasionally in New York State Court, because apart from the Americans with Disabilities Act, various states, including New York and California, have their own sets of laws that apply to website accessibility or accessibility in general. So we've seen a lot of these lawsuits, and of course a lot of demand letters, pre-suit litigation letters seeking remediation, as well as of course damages and attorney's fees. Many, unfortunately, in my opinion, too many of these cases.
So we continue to see this litigation, so it's not going away, and it really it's somewhat of a plateau, but it actually seems to be bouncing from that plateau and going upward. What is it that most people don't understand about website accessibility litigation? Why do we continue to see these lawsuits?
Well, I think for starters, there are a lot of companies that have e-commerce websites that don't even realize that the Americans with Disabilities Act or other state and local laws apply to websites. I think many people are just unaware that websites can be made accessible through screen reader technology and other technology, so that visually impaired and blind people can actually navigate and enjoy websites in a way that visually normal people are used to enjoying them. I think it just doesn't occur to a lot of people, and that's unfortunate. So, in a sense, these lawsuits do bring news about this to website owners and force them to make their websites accessible, which is good, and they should do that. But I think it really comes back to just a lot of e-commerce owners aren't even aware of it, and small businesses, they're a little overwhelmed with all the different regulations that they have to comply with. So it's just not even on their radar.
As you touched on, we do know about the complaints filed in state and federal court. Those have started to make their way into the mainstream knowledge. But what I don't think everybody knows is just how much more often that these matters are settled before a complaint is filed, or they may even preempt a complaint, as you mentioned earlier. So how much more litigation is informal versus actually makes its way into a complaint filed in court? Can you give us an idea?
Yeah, so that's a really tough one. I don't know how many demand letters go out pre-suit. I would imagine, it's easily 25%. Maybe it's higher. I don't have a good statistic on that, but again, because those just aren't public knowledge. But I suspect it's a significant percentage. Quite a few of those letters are going out without lawsuits being filed.
And so my next question is, with when when a demand letter is received. I've read and I've heard from people, and there's the inclination to respond directly to plaintiffs' law firms. And I wanted to ask you, why is it advisable to consult an attorney in these matters rather than just the instant reaction is to try to dispel the notion or quell this and make it go away, or try to counter what the plaintiff is asserting or the plaintiff's lawyer is asserting. But why is it advisable to consult with an attorney first?
Well, whether you get a demand letter or receive a summons and complaint, meaning a lawsuit's been filed, I think it's always a good idea to consult a lawyer. If you don't consult a lawyer and you're not familiar with this type of litigation or the demand letters, you're not going to know what typical settlement ranges are. And I will tell you from experience, the settlement demands often start quite high. And in fact, the real number that these plaintiffs' lawyers will settle for is substantially less. So contacting a lawyer, you may get a demand that starts at $45,000 in that range and be able to settle the case for $15,000. Or if you're a very small company and you just don't have the financial ability to pay even $15,000, with a lawyer, you may be able to get that down very significantly and more than offset the cost of the legal fees, which are relatively small, I would say, in most of these cases to resolve. If you have a party that wants to settle the case, a defendant that wants to settle the case, I think these can be done fairly quickly. And also you get a settlement agreement that provides for a lengthy period of time to properly remediate the website, and that hopefully will prevent second, third, fourth additional lawsuits and demands coming on.
Much of your experience with website accessibility litigation comes by way of your current clients. They receive a demand letter or a complaint is filed against them. Can you tell us about the typical experience from start to finish with one of these lawsuits or demand letters?
Sure. So when my clients call me and say, "Hey, we just got this demand letter, or we just received a summons and complaint. What do we do about it?" My response is, there's a way to resolve this. Obviously, through a settlement, you can do that. You could fight depending upon how strongly you feel. Unfortunately, I think most of these cases end up settling in a dollar range that makes it far more cost effective to settle, to agree to remediate rather than to litigate. But I think where the additional advantages coming in of getting a lawyer, in addition to getting a lower cost to settle, is the terms of the settlement agreement, the length, as I said a moment ago, the amount of time you have to remediate, the level of compliance that you're going to aim for, and then, of course, getting some guidance on who to work with and how to best improve the website to remove digital barriers and hopefully avoid future lawsuits.
Can you talk more about those conditions that you just mentioned? So what are some good baselines to strive for when settling? Like what is a good time frame for having an audit conducted and then also remediating? What are you typically looking for with those numbers?
So I would say that I've seen plaintiffs' law firms typically out of the gate offering 12 months to fix the website, remove digital barriers. I often push for 24 months, sometimes even as much as 36 months. Not that I'm telling my clients to wait that long to remediate the website, but it gives them a longer tail where there's a settlement agreement in place. If it's following a lawsuit, you have a settlement in a case where a judge has already been assigned in federal court, and often you can use that as a way of preventing future lawsuits. If you get sued by another plaintiff's firm, you can say, "Hey, we've already entered into a settlement agreement. We have 24 months or 36 months. We're already working on this," and it's really a form of protection for the company for future lawsuits, because these are typically one-off settlements, not settling for the entire class of visually impaired people across the entire country. The other part of it is picking the right standard to aim for as far as compliance. And we've talked. I'm sure you've talked about WCAG 2.0 or 2.1, and whether it's AA, AA, AAA. And I often aim for 2.1 AA, but I'm sure that standard is going to be revised soon, I would imagine. But that's typically what I've been aiming for.
Yeah, the 2.2 is expected to be released in August, so very soon. So we might see reference to that soon. But in the meantime, I think you've touched on this. What are some best practices to prevent litigation?
Well, of course, the best practice to avoid litigation is to have a website that is, to the greatest extent possible, free of any digital barriers, so that people who are visually impaired or blind can use their screen readers and not encounter barriers getting to the checkout screen and being able to make a purchase and complete a purchase. So having your website audited really by somebody who's familiar with website accessibility. I think having a human being rather than a bot or some program check your website is really the best practice. And then keeping on top of your website. Websites are not static. They change frequently. Every time you add a new product and take away an old product, you have to be sure, if you're showing an image of your product, to include alt text, to make sure that it is accessible, that it doesn't create problems for screen readers.
I think that's exactly that's another problem that people are not understanding about accessibility, is that this isn't. I think people are looking at this as like a checkbox. What do I need to get to this checkbox? And then they might settle a lawsuit, and then they think they're done with it, and then they forget about it, and then it reintroduces itself. Are there any industries or types of websites that you see targeted more than others in litigation?
I'm not sure that there's any particular industry, although I have noticed there are some plaintiffs' law firms that will target a particular industry at a time. So I've had, in a stretch of a week, 2 or 3 clients call me saying that they received letters or lawsuits virtually on the same day because a plaintiff's firm is targeting a particular industry. I remember a couple of years ago, it was every art gallery in New York City, where 2 plaintiffs' law firms basically split up the alphabet and went after, I don't know, 30 or 40 galleries all at the same time that had websites, and they all presumably had to either litigate or settle those cases. So I've seen industries targeted at a particular time, but I don't think there's a particular industry that is more frequent than others as a target.
I've seen the same. My impression is it's random, but when they decide to channel their focus, they do. And I've seen, I've heard about the breweries, microbreweries, marijuana shops. It happens in California and New York. Seemingly, those are the 2 places where they find a niche and then they go after it. When you deal with plaintiffs' law firms, are they ever open to dismissing a complaint or withdrawing a claim in your experience?
I think that is very infrequent, unless, as I said before, you have a defendant who has recently been sued and entered into a settlement agreement, and where you produce that settlement agreement that says we have 24 months and we're still within that window, and a judge has already signed off on this. In those cases, those new second, third lawsuits often get withdrawn.
Okay, so the technical term here is consent decree, right? Is a consent decree that's.
Well, it would be a settlement agreement. In federal court, you would have a settlement agreement that gets usually submitted to a judge, or you'll have a notice of withdrawal, and you don't actually submit the settlement agreement, but essentially it is, approved by the court.
Okay. What you've talked about settlement amounts previously. So you said sometimes the starting point can be 45, and then that might end up at 15. Can you this is something that so many people are wondering about because they find themselves in this situation and then they decide ultimately I don't want to pursue defending this case. I just want it to be done with. Can you just take us through the range of settlement amounts and what happens? What are some factors that affect the settlement amount?
Sure. So, and by the way, I don't have all the information, all the science on this. This is just my personal experience. I typically see plaintiffs' lawyers asking for 40 or 45,000 as an opening offer, but expressing a willingness to reduce that. And different firms have different mindsets on where they want to resolve these cases. Some of them are in the $20,000 to $25,000 range. Some of them will go down to 15 at the low end. In cases where the defendant, as I said before, is really not financially able to afford $15,000. A company that has $200,000 in sales a year, and the profit on that is far less. They really can't afford to spend $15,000 on a settlement and then also work with the company to identify digital barriers, which can be expensive in and of itself. And then, of course, having somebody improve the website, it becomes very costly. So with some of these smaller companies, there are a number of plaintiffs' lawyers out there who will just say, okay, with a confidentiality agreement, send me your tax return, send me a P&L statement, prove to me that you really don't have the financial ability to pay, and we'll take that into consideration. And I've seen those cases settle for considerably less, and then still have to remediate. But typically, I would say most of these cases are settling $15,000 to $20,000 range, depending upon who the plaintiff's lawyer is.
Well, that is some good news for the smaller businesses, and New York is at the top, right? Like New York is known for having the higher settlement amounts. That's what I've heard, and then so that's also good. I have two more questions here. Are there any notable developments that you've seen in the legal landscape? So trends with law firms, recent court rulings. Is there anything that is unfolding recently that's affecting this landscape?
So not recent as in the past month or so, but I do think there's an avenue to litigate some of these cases because really these plaintiffs' lawyers who are getting $15,000 or $20,000 to settle these cases, I think, are getting more than they're really entitled to, at least under the Americans with Disabilities Act. The plaintiff is entitled to recover their reasonable attorney's fees, and typically these cases involve a complaint being filed. So there's a filing fee of several $100s, but they take a boilerplate document. Maybe they use their own automated search tool to identify digital barriers. It's not a lot of money, and I presume, although since I'm not a plaintiff's lawyer, I don't know, but I presume that they're having either a paralegal or an administrative assistant or somebody putting together these complaints. So it's not as if a lawyer who's billing at $1,000 an hour is really spending time. So the cases I've seen out there, a couple of them, basically a defendant has said, I admit my website isn't accessible. I am prepared to fix it, and court, let's have an inquest on what the attorney's fees are. And the attorney's fees, maybe they're $5,000, $4,000. They're not. They shouldn't be $15,000, $20,000, $25,000 in my experience. So if you can get a lawyer who is willing to just file those basic papers, ask for an inquest, I think you'll end up saving money. But there's some risk there. You have to hire the lawyer. You have to go to court. It takes a little bit of time, and I think those cases should be coming along and really driving down the settlement amounts from the $20,000 or $15,000 range, much closer to 5 to 10, in my opinion.
And with that in mind, just how important is it for someone to hire an attorney who has experience in this space?
Well, sure, exactly right. There are plenty of lawyers out there who certainly are very good at what they do and are able to appear in court. But if you don't have that background, the experience to know what the typical settlement ranges are, then you're negotiating from start. It just takes more time. If you want to have a lawyer who's starting drafting a settlement agreement from scratch, that's going to take more time. So I would say finding a lawyer who's done a handful of these cases at least and is familiar with the standard settlement agreement, what you can ask for, what you can get, what you can drive the settlement price down to, is worth the cost of getting a lawyer who has that experience.
And so for the last question, I want to ask you, how do you see this environment playing out in the next few years? What's going to happen with website accessibility and ADA compliance?
Well, as you said just a few moments ago, we're going to have an update on the WCAG standard, I expect, relatively soon. I don't imagine that the federal government, the Justice Department, is going to issue their own standards. They've been asked to for more than a decade now, and they have not done it. I don't see this getting the attention of Congress, although there has been a bill offered every year for the past couple of years to try to prevent plaintiffs' lawyers from using the ADA as a tool to generate income for themselves. And of course, that's only the ADA. That doesn't address the California or New York state laws. So I don't see these, unfortunately, going away anytime soon. Perhaps the technology will improve so that it is easier to really properly check your website and see what the digital barriers are and fix them. And I suppose with continued lawsuits and news outlets and YouTube channels like yours, people start to get the message that they really need to pay attention to this, or they're going to be hit with a lawsuit, and it's going to cost them $10,000, $15,000, $20,000 plus the cost of remediation. And it's an added burden on these small businesses.
Well, that is all the questions I have. Jeremy, thank you so much for being on. This is going to be extremely helpful. I know there is so much litigation in New York, so it's great to hear firsthand from an attorney who practices in New York, your experience and this information. Thank you so much. Are there any final words you have to people who are watching and listening?
Sure. My final thought is, and I think Chris, you and I agree on this. Everybody who has an e-commerce website should really strive to make the website accessible. Set the law aside for a moment and set the potential litigation aside for the moment. You want to make your website accessible to the greatest number of people because you want to sell your product to the greatest number of people. So I think it makes a whole lot of sense to spend the time and spend the money and getting your website accessible. Just as a matter of an ethical obligation or reason, putting the law aside. I think, as we've said, we'll continue to see a number of these lawsuits out there, and it's upsetting to me personally because I think most plaintiffs' lawyers are doing this in part to bring the issue to light, but also greatly to put money in their pockets at a tremendous expense to small businesses, which I think is unfortunate. So, check your website, get it accessible.
And if any organizations should want to reach out to you and contact you, what's the best way to do so?
Sure. So the best way to do so is to reach out to me by email. It's just the first letter of my name. So the letter J, Richardson at sgrlaw.com. That's all strung together. You can also look me up at sgrlaw.com and you'll be able to get all my contact information there.
And I will link to you in the YouTube description and provide that information there. Thank you so much for taking the time, Jeremy. I really, really appreciate it.
It's my pleasure. Thanks so much.